Our next and final oral argument of the morning is Palmer versus State of Florida, case number 250287. Mr. Ufferman from Tallahassee, when you're ready. Rebuttal time?
5 minutes, Your Honor.
All right. Please proceed.
Thank you. May it please the court. Good morning. My name is Michael Ufferman, and I represent the appellant, Christopher Palmer. The sole issue in this case concerns whether the trial court erred by denying my client's timely motion to withdraw his plea. The argument in my client's motion was that he was affirmatively misadvised by his criminal defense attorney as to the impact of his criminal convictions on the pending or the civil suit that he wanted to pursue.
Counsel, can I make sure I understand? Your position basically is your client was promised by his lawyer that his plea to the misdemeanor level crimes would not impact his civil suit, his related civil suit against Geico, right?
Correct.
Okay. Yet during the plea colloquy, under oath, your client swore that he was not promised anything, and in the written plea agreement, your client, I'm assuming it's under oath, but it's not disputed, your client promised, or your client swore he had never been promised anything to get him to make this plea, correct?
Correct.
Okay.
So let me respond to that then.
Might as well, because that's what it's all about, isn't it?
Maybe. That's not really one of the three reasons that the trial court gave, but it is certainly an issue in this case. So regarding the plea colloquy, I submit that obviously that's a collateral consequence. And I submit that a fair interpretation of the question in any criminal plea colloquy is, have you been promised anything relating to the criminal case? And I say that for a couple of reasons. You could imagine a defense attorney saying, you know, as soon as we get out of here today, I promise you I'm going to buy you the best steak in town. Of course, if the question is asked, have you been promised anything, you wouldn't expect a criminal defendant to say, oh, my attorney promised me a steak. Let's make it a little more impactful. Let's say the attorney says, when this is over, you were on the police force and now you're going to get your job back. Or when this is over, you're finally going to be able to see your kids again. Those are all collateral consequences that you wouldn't expect a defendant to answer in response to that question. So I think that's one of the ways to distinguish it.
And there's so much testimony in the hearing transcript on the motion to withdraw the plea that your client always knew from, I want to say it was March 2023, but I could have that date wrong, whenever he dismissed it, whenever he dismissed his civil case, and I gather they were moving to dismiss because he wouldn't testify, wouldn't give a deposition, wouldn't come to court, whatever it was, and the only way around that was to take a voluntary dismissal. I get it. We've maybe not all been there, but we've been there. So he knew about this. This was not, what was he going to get to eat, something like this. He said in the hearing, I'm 100% innocent. I was never going to do anything but go to trial. My civil case depended on the outcome of the criminal case.
Yes.
So this is not, I get it, and I understand what you're saying. I don't disagree that the judge may be thinking, is anybody promising you to the sentence or that? I get that. But this is a guy where it's so central that even before he takes the plea, he's telling Martinez, look, this can't affect my civil case. This plea can't affect it. I promise you it won't. Anybody promise you anything? Nope.
Well, I think the same thing is true of the two main cases, three cases, I guess, that I've cited in my briefs, Chandler, Lundgren, and then Trenery. Chandler involved conditional release. There was promises made in Chandler regarding conditional release, and no statement during the plea colloquy in that case about, oh, he promised me something about conditional release, which is obviously what led to the request to vacate the plea. The same thing in Lundgren, first DCA case, that was game time. So I think these are things that are collateral and wouldn't necessarily come front to mind of a criminal defendant when being asked all these questions specifically about the criminal case. You're giving up your right to a trial, you're giving up your right to call witnesses. Has anyone promised you anything about this case? Again, I think a criminal defendant is going to interpret that, just as you indicated, Your Honor, that this relates to the sentence that I'm going to get as a result of this plea, or this relates to the 2 charges that are going to be downfiled from felonies to misdemeanors. The other thing is...
In the plea statement, though, no person has made any promises to me that induced me to enter this plea except those matters specifically set forth in this plea agreement. And again, I get it that the client's there, he's in court, all the rest of that, but if you look at this like any other contract, nobody made any promises to me about the punishment, the sentence, or anything to do with this case. Any promises. And clearly, your whole argument is Martinez made him a promise that induced him to do this plea.
So that's the standard plea colloquy.
I understand.
There's a number of cases that talk about general versus specific, and if a specific question is asked during the plea colloquy, then the defendant is obviously stuck with that answer, but general questions generally aren't going to cover this type of specific issue, number one. So clearly, if the question had been asked, whether the trial court was aware of it or not, but if the trial court had been aware of the civil case being an issue, oh, by the way, has anyone promised you anything about your civil case? By all means, if he said no, then I wouldn't be here today. I wouldn't have agreed to take this appeal. But the other aspect is the judge didn't make a finding on credibility on that. The judge made one credibility determination against my client, and that is that she doesn't believe he really would have not accepted the plea. And I'll address that in a second. But she doesn't dispute that Martinez really did tell my client this, and that's kind of what the plea colloquy goes to. So the idea that, oh, you said this in the plea colloquy, therefore it can't be true that something else was promised to you. I think everyone agrees the trial court certainly took it as a given that Martinez really did promise to my client that these misdemeanor pleas will have no impact on your civil case. So I think, again, when you look at the manifest injustice standard and interest of justice is always a consideration when there's a timely motion to withdraw a plea. The plea colloquy, the general question reasonably could have been interpreted as not covering collateral consequences, but more importantly, the trial court made no finding the promise was not made. So if I could then turn to, well...
How could they? The other guy in the conversation's dead.
True, but that's not my client's fault.
Well, no, I didn't say it was. but again, going back to the written plea, the law is it's contract, and in that contract it says, no person has made any promises to me that induced me to enter this plea. And that's exactly the argument you're making, that Martinez made a promise to him that induced him to enter into this plea.
But if that's true in Lundgren, when the first DCA said there was a promise made about gain time, and the defendant was allowed to withdraw his plea. That's true in Chandler when there was a promise made about whether the defendant would have conditional release. Those are, again, things that weren't brought up during the plea colloquy because I don't think that's on the front of a defendant's mind when being asked specific questions about, is there anything that's inducing you to enter this criminal plea regarding the charge you're going to have and the sentence you're going to have. I think that's when we talk about collateral versus non-collateral consequences. I think the plea colloquy, I understand it has broad language, but I think it can be reasonably interpreted to include the criminal sanctions at issue and doesn't address, or a reasonable person wouldn't necessarily interpret the question to mean that it includes all these collateral consequences, such as conditional release, such as gain time, such as the other issues that I gave, like you're going to be able to have contact with your child, you're going to get your job back. Those are all things that may be discussed that I don't think we would expect a reasonable criminal defendant to answer when being asked that question. They're being expected to answer, no, I was told that I'm only going to get 1 year probation, or I was told that if I didn't take this plea, my attorney was going to, sue me for money or was going to inflict some type of physical harm on me, and I was pressured into taking this plea. That's what the reason for the question, and I don't think the reason for the question would bring out any other collateral consequences that may have been discussed in the case. Again, the best examples I have of that are Lundgren and Chandler, which allowed those issues to move forward even though there was a plea colloquy in that case.
How do we know for sure that Mr. Martinez gave misadvice? Just the fact that the civil lawyer was no longer comfortable taking the case?
Well, my client's testimony is what establishes that.
that the civil lawyer wouldn't take the case, that there could be dozens who would take the case.
Oh, I'm sorry. So going to the prejudice issue, and I think the trial court misunderstood that. The trial court said, well, you're not prejudiced by his misadvice because you can still refile. But that's not the prejudice that's at issue. The prejudice is by entering the plea and having these two misdemeanors, which are crimes of dishonesty, that impacts the ability to move forward with the civil case. That's the misadvice. So yes, he could refile, but that's a red herring.
That impacts this attorney's willingness to take the case, but maybe there are other attorneys. Do we know anything in the record? Other attorneys who say, I don't care about the misdemeanors, I'll take the case.
Well, this attorney told him having those crimes of dishonesty while you're trying to pursue this case against Geico is going to negatively impact your ability to win. And that's a fact. I mean, I don't think that's disputed. That obviously, if he's going to testify, regardless, Geico, I'm sure, is going to introduce the fact that he's been adjudicated guilty of crimes of dishonesty. That's going to have a negative impact on his case. And think of it in the context within which it was told to him. This is being sold as you're getting misdemeanors, not felonies. So initially, he's obviously charged with two very serious felonies, a second-degree felony and a third-degree felony.
And if he withdraws his plea in this case, he's back to facing the felonies, right?
Correct. Which further shows that the real reason he wants to withdraw his plea is not anything else other than he was given misadvice. So you could have a situation that a week after the plea, he violates probation. And now he's thinking, oh, I want to get out of that plea real quick so I don't have to face VOP consequences. We don't have that in this case. We have a situation where he was actually offered a 5 to 7 year probation offer earlier in the case. He rejected that.
He got a more favorable offer.
Well, no, but at the time, he wasn't sure he was going to get that more favorable offer. And it shows...
If we rule in your favor, can your client now refile that civil suit?
That's not apparent on the record. And I'm not a civil attorney, so I won't step out of my lane.
Well, I mean, they kept talking about 5 years. The 5 years hadn't run, all the rest of it.
I can't answer that question. And the record doesn't answer that question.
Yeah, I didn't see it in there, but all I kept saying was the 5 years, and the 5 years is gone.
Sure, of course. So, wow, he could be taking a big risk by wanting to go forward here. This court grants relief.
Because all this, he could wind up, I know he didn't score prison time, but
he
they
could
were
get
talking about
20 years.
He could have been looking at big time. Also, he could have a suit that would be barred by the statute of limitations.
Yes, he understands that completely, but there's no other
Promise that? No, I'm just kidding.
There's no other explanation that would explain why he filed this motion other than what he said in his testimony. The very next day, he reached out to
San Sebastian or something close to that, right?
Santisteban is what I thought it might be, but you were probably correct, Your Honor. He reached out to his civil attorney. His civil attorney said, wait a minute, this isn't going to work. This is going to negatively impact your civil case. And then one point I want to make, just to go back briefly. When explaining this to him, it really was explained in the context of, you're getting misdemeanors. And oh, by the way, I myself, this is Martinez, I had an issue with the Florida bar, that I was able to get my charge reduced down to a misdemeanor, and I kept my license because of it. So he's clearly telling my client that, oh, it's the fact that this is going to be reduced down to misdemeanors that you're going to be okay. That's not correct. And as soon as he learns out it's not correct, he takes the time. Can't happen overnight, but he goes out and gets another attorney, Mr. Roden. Mr. Roden puts together the motion timely to withdraw the plea, and that's why he's pursuing this motion to withdraw the plea. So to say that the reason the judge gave for the first reason for denying this is, the only credibility determination she made, I don't think he's credible when he says he really wouldn't have accepted this plea. It's because, you got the deal of the century. You were facing 20 years, and look, you now got it down to 2 misdemeanors and 2 years of probation. I don't really think you would have rejected the plea. Well, again, why else would he be filing the motion timely so quickly thereafter? Nothing has changed. The only possible reason it could be exactly what he said. And the fact that he previously rejected that 5 to 7 year probation officer further shows that, he didn't want felonies. He only wanted something that made it so he could move forward with the civil case, and he was told that these misdemeanors would allow him to do so. That was affirmative misadvice. And in the Chandler case, the second DCA specifically said affirmative misadvice, even about a collateral consequence of a plea, constitutes ineffective assistance of counsel. And obviously in the Lundgren case, the first DCA said a criminal defendant is entitled to reasonable reliance upon the representations of his counsel, and if he is misled by counsel as to the consequences of a plea, he should be permitted to withdraw his plea. Those two principles in the interest of justice apply in my client's case. All three of the reasons that the trial court gave are simply contrary to the record, not supported by CSE in the record. Regarding the second reason the trial court gave was, it was common sense that he would know that these pleas would affect his civil case. Well, wait a minute. I don't think it's such common sense. He's being told by his own attorney that his attorney had a bar issue, but when it got reduced to a misdemeanor, the whole bar issue went away. He's relying upon his attorney's advice. So, yeah, he has a right to rely upon that advice, as I just read. So, yes, he knew that there could be an impact from the criminal case on the civil case, but now he's being promised, I assure you, these misdemeanor convictions won't impact your civil case. The second reason the judge gave is erroneous. And again, the third reason goes to this idea that, yes, he can refile. That's not the prejudice. Of course he can still refile. The question is, are the misdemeanors going to have a negative impact on the civil case? And the answer is clearly yes. So for all those reasons, I'm asking this court to simply allow my client to go back to square one prior to the point where he got this improper advice. Yes, square one subjects him to both of these charges and up to 20 years in prison, and the judge will make a determination about whether or not the handwriting expert is admissible, and that may go against him, and that may hurt his defense at trial. But my client was affirmatively misled as to what would happen in this case based on his attorney's misadvice, or what would happen in what the impact would be on the civil case based on the plea result in this case. And the case law is crystal clear that a plea has to be voluntary, and this plea was not voluntary, and there's no evidence that refutes my client's claim. All the evidence in the record supports my client's claim. I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, Mr. Efferman. On behalf of the state.
Yes, Your Honors. Good morning. Zach Wiseman on behalf of the state of Florida. I have a few brief remarks prepared, but if the court obviously has any questions or concerns, just feel free to chime in. Just to address a few of the points that Mr. Efferman brought up, sort of the motivation for wanting to withdraw this plea. I think it bears mentioning that at the time that the motion was filed and at the time the evidentiary hearing was conducted a few months later, Mr. Palmer was still on probation. He was under the active effect of that sentence. Now, while the record seems pretty clear that he was doing good on probation, ultimately ends up terminating, I did want to address that point, that he still does have something to gain if he wants to go back to square one. I think that overall, there is some evidence that points to in the record and in his testimony at the evidentiary hearing that that perhaps there were other reasons for him wanting to enter a plea that day. There was great discussion about the motion in limine that the state had filed. It was seeking to basically exclude a handwriting expert, and it sounds like from what we can gather from the limited evidence contained in the record that Mr. Palmer's defense was very, very, very dependent on that expert's testimony to demonstrate that, I'm assuming he had been alleged to have forged some documents is part of this. And Mr. Palmer, in his testimony at the evidentiary hearing, he does say, I believe it's on page 285 of the record, regarding the motion in limine, he says that's why the plea was entered. And there's another point earlier in the testimony on direct where he says that the most important component of his defense was the expert. Just so to sort of paint a clear picture of the timeline, we're at jury selection. There's a motion in limine filed, I believe, the Friday before. Presumably they're there the following Monday. They begin to sort of hear the motion in limine. It sounds like it's going to go to some sort of Daubert hearing to determine whether or not the expert could properly testify. And during the intermission to that, they come to the plea agreement. Mr. Palmer pleads to the misdemeanors, and the rest is history. So we have a jury waiting, it appears. We have the motion in limine pending, and Mr. Palmer has made a great offer. I think probably everybody would agree that misdemeanor probation is a pretty good outcome. He ends up doing, I believe, 1 year out of a 2-year probation term, down from a second-degree and a third-degree felony, the potential of up to 20 years state prison. It was indicated at the plea hearing that he scored 28 points. He scored permissive prison. So the full brunt of potentially 20 years of prison and or probation is sort of staring him at the face, and there's a jury there ready. I want to bring up a couple points about sort of the fact-finding that the court engaged in and the testimony at the hearing. There's this idea that, according to Mr. Palmer's testimony, which unfortunately Mr. Martinez passed away, as Judge Edwards, as you pointed out, that's obviously not Mr. Palmer's fault, but there's this idea that they had this meeting, and we have the email. I believe it was in March of 2023, if I'm not mistaken. And the email's in the record where he says that, we had a meeting. He's basically memorializing that meeting with all the parties, where he's saying that everything is, intertwined, that these two matters are factually related. The allegation here is that he basically tried to, defraud Geico with a fraudulent insurance claim, and then he's trying to, I'm assuming, sue Geico for, basically not paying out that claim. Again, there's sort of limited information in the record, but I kind of understand that is, I'm assuming that is what's going on. There was a motion to dismiss, one with prejudice filed by Geico, where they had apparently proffered some evidence of fraud, and the court had set it for an evidentiary hearing a couple weeks later, and that's when Mr. Palmer agrees to voluntarily dismiss the suit. To me, it already sounds like, and I think that Mr. Santisteban, I believe is his last name, in his email is sort of pointing out that there are already issues with the civil case. He's concerned about it surviving a motion to dismiss. Mr. Palmer, mentions the conversation he had with Mr. Santisteban, or sort of the conversation as he recalled it and claimed it went down, is that Mr. Santisteban had basically told him, no juror is ever going to believe you. You're now a thief, right? Nobody's going to believe you. I think the idea that no juror would believe him when we were already concerned about maybe losing a motion to dismiss is...
Counsel, as of March 23, when they took the voluntary dismissal, is there something in the record that tells us exactly what their motion to dismiss was?
There is not. I can refer to the email briefly.
Well, I've seen the email, but I mean, it's like...
I don't believe we have a copy of the motion or court minutes or anything like that.
Right, so we don't know if they were getting it dismissed based on fraud, or if they were getting it dismissed because
Right.
he was taking the fifth and wouldn't testify, right?
Right. I do know that Mr. Santisteban had indicated that someone from Mr. Palmer's camp would have to testify, most likely to survive the hearing, and that would probably have to end up being Mr. Palmer himself. So, but that's really the only indication we have. We don't know the subject matter of that hearing or
Right, so
of
we
that
don't know
motion.
exactly what it was,
We
what the
don't.
nature of the problem was with the civil case. Once he's pled guilty and been adjudicated guilty of two counts of theft, then that is something that could come in during his testimony in a civil suit, correct?
I would assume so, especially in the context of, he's making admissions to a factually related case. I think that there's probably a couple of ways that can be used.
I mean, again, I don't think there's a real question about whether that could damage his case, whether he had a great case and now he had no case, or he had a crummy case and now it's even crummier. It still would impact his case, wouldn't you agree?
I would agree with that.
Okay.
I think
That's why he moved, according to Appellant's counsel, that's why he moved to set aside his plea and no other reason.
That's correct. And that brings me to sort of my next point, which is the credibility of his statements at the hearing. I mentioned before briefly that he is still under the active sentence. Obviously he got off of probation. That's great for him. There was no indication that he was doing poorly, but he could still maybe not want to be on probation. I know he had agreed to pay some restitution as part of the plea offer. I don't believe that was to Geico. I think that was the Department of Financial Services, if I'm not mistaken. But there's sort of the idea that at the hearing, his testimony, he's talking about why he has waited so long to enter a plea, why he does it on Jury Monday. And he he mentioned several times, he says, something along the lines of, I'm 100% innocent. Why would I enter a plea? I was 100% innocent. And then we start getting into the expert was really important to my defense. And then we get into, the motion in limine. Well, that's why I entered the plea, is to, I take from that, and I think maybe the court was sort of alluding to this in the order, is, he sees that maybe his defense is not going to work out. If we kind of, and then going back to the actual plea colloquy in the plea form, as Your Honor pointed out, he affirmatively states he was promised nothing, he was not pressured, he was not coerced, nobody was forcing him to do it. The court finds, correctly at that time that he was entering the plea freely and voluntarily, and he understood what he was giving up. I think that in a situation where, Palmer brings up the monetary damages he's seeking, he says it's something over $200,000, I believe was the testimony in the civil suit. One point I certainly disagree with counsel on is that whether or not a reasonable person would have brought that up. I think that a reasonable person, if they were promised, explicitly promised, this will not affect that, might have brought that up to the judge's attention.
Well, I agree with the word might. They may have, they may not. Again, I don't know how many times you've actually sat through a plea colloquy when somebody's...
I've sat through thousands.
Okay, well, great.
I was a trial attorney.
Well, then you know that sometimes you get the deer in the headlights kind of look from a defendant,
And I've seen that.
They may or may not really understand,
and I've also seen people who bring everything up, and it's it's a full-on 20-minute.
we don't really know here if Palmer was thinking, well, yeah, he told me my civil case would be okay because these are just misdemeanors like his drunk driving thing or whatever it was.
And I think, again, going back to his credibility is, it's the timing of everything is, I think, casts doubt on the true motivation for wanting to withdraw the plea. Basically, he argues it would have, had he known it would have affected his civil suit, he would have never done it. But he's made a great offer at the 11th hour. There's a motion in limine pending that he might very well lose. I think, Attorney Martinez allegedly told him it was like a 50-50 or something of that nature. There's a jury sitting there. He knows full well that if the trial doesn't go his way, I'm sure he's been told at this point numerous times in court or by counsel that he could go to prison. It's certainly not outside the realm of possibility. I know fraud is something that's generally taken quite seriously at the trial level. And, I think that casts doubt on the credibility. And when we go, this is sort of brought up in the answer brief, we have to, not only determine the credibility of his statements, we have to determine prejudice, which in this context is essentially but for the misadvice, would he have elected to go to trial, and is that a reasonable decision? The factors are from our Supreme Court in Grosvenor, and they come to us from Hill v. Lockhart in the U.S. Supreme Court. Just getting those for you right now. But it's a totality of the circumstances test, and in determining whether or not it's a reasonable decision, you have to consider circumstances such as whether a particular defense was likely to succeed at trial, the colloquy between the defendant and the trial court at the time of the plea, and the difference between the sentence imposed under the plea and the maximum possible sentence the defendant faced at trial. So, working backwards, there's obviously a massive gulf between the sentence he got and the sentence he could have received. We have potentially 20 years versus 2 years of probation on misdemeanors, not on felonies. If he were convicted at trial, he would almost certainly be getting adjudicated guilty of the felony offenses, and he would have to live with the attendant consequences of that. The colloquy, again, there's no specific mention of this civil case or the other sort of outside ramifications, but there is the generalized plea colloquy, and we do have the case law that tells us that you're bound by your answers in the plea colloquy. You're under oath. This is an agreement between you and either the court or the state. There's a finality interest here. We're resolving the case. This is a serious hearing, perhaps the most serious, assuming a case doesn't go to trial. And then we have whether or not the defense was likely to succeed at trial. And I think by Palmer's own admission at the hearing, he wasn't terribly confident with that motion in limine that he was going to succeed at trial. If that expert goes away, it sounds like it would have been an uphill battle from his understanding of it, from the attorney's understanding of it. And then just a few other kind of minor issues I wanted to point out was, the order denying the motion points out that the civil attorney, Mr. Santisteban, had said that he would consider refiling at a later date, depending on how the criminal case resolves. I don't see that as an affirmative promise that he would refile it. And then the other thing that I think sort of goes to his credibility in determining whether or not his true motivation was to pursue that civil case is he didn't talk to any other civil attorneys. He says that in the hearing that he just talks to Santisteban, and Santisteban apparently tells him, no, we're not going to do that anymore. This isn't going to work. The motion is filed a few weeks after the plea hearing. The evidentiary hearing happens, I believe, 4 months later. I think it happens in August, and the motion was filed in, I want to say, April. He doesn't talk to any other civil attorneys, and according to Palmer, there were over $200,000 in damages at stake. That was his understanding that he conveyed to the court at the evidentiary hearing, and he doesn't talk to any other attorneys. He just took what Santisteban told him and just sort of ran with it, and wanted to withdraw the plea. Didn't at any point, it sounds like, consult with another attorney about, like, hey, is this really that big of a deal? I think that would be a very reasonable thing to do if one were truly concerned about the civil suit primarily and was sort of willing to risk it all to pursue this. And he still had until, I believe, January of 2025 to refile the suit. And going back to the idea of whether or not he can even still do that, the short answer is I don't know off the top of my head. But according to Mr. Santisteban's email, if he was conveying accurate information, that period has passed, and I'm not so sure it would be told. And then the fact finding in the judge's order, she does, as counsel points out, she does find Mr. Palmer credible in at least one area. She finds that he did testify credibly that he had his civil attorney since 2019 and was aware that his criminal case was affected the civil case since March of 2023. The court believed that essentially strengthened her finding of the lack of credibility, that his statement that he would not enter the plea, she found that he affirmatively knew that his criminal case, which was factually intertwined, would affect his civil case. She finds him incredible in certain other areas. But I think that speaks to the court engaging with the testimony and with the exhibits and making a fair finding. The case law tends to give great deference to trial courts, and when they're sitting in a fact-finding role, the same as we do to a jury, they can consider the credibility of the statements and all manner of things. And I believe I've probably reached where I sort of prepared to address. Does any of the court have questions or comments? All right, well, thank you for your time. I ask that you affirm the denial of the motion to withdraw the plea, and thank you.
Rebuttal?
Thank you, Your Honor. May it please the court. I'm going to address a couple of quick points, and then I want to take another stab at the plea colloquy. I am just a simple lawyer from Tallahassee, but I'm not fully understanding the idea about, at the time he was facing 20 years in prison, and he was facing the judge potentially denying the motion or granting the state's motion limine and excluding his expert handwriting expert, and therefore that would have hurt his defense. So those are all the reasons why he wanted to enter the plea then. That's true, but if he wins this motion, all of that is back on the table. He's still facing 20 years. He's still facing 2 felonies. He still needs to have the judge rule on his motion, or the state's motion to exclude his expert, and he still could be found guilty after the trial. So that supports my client and his credibility that the real reason he's still facing all that, nevertheless wants to withdraw this plea because he was lied to. It was mentioned that the other benefit out of this is maybe he didn't want to be on probation. I submit, that in light of all the evidence in this record that's confirmed by an email from the civil attorney, that the real concern in this case was the civil case, that I don't think my client 2 days later woke up and said, I really don't want to be on probation. I got to come up with a reason to try to withdraw this plea. Let me use the civil case as an excuse. I just don't think that's what's happened here. And then finally, before I move on to the plea colloquy, I want to address what's said on page 285. This is my client's testimony. They're talking about the fact that the judge hadn't ruled on the state's motion in limine regarding the handwriting expert. And the question is, and you're aware of that when you entered the plea on April 8th, yes. So that was prior to entering the plea. That was prior to entering the plea because that's why the plea was entered. I don't think he's saying that's why I entered the plea. I think in context he's saying it was the question, the ambiguity about what the judge was going to do with the state's motion in limine that brought up the plea discussions that led to the plea. I don't think, if you look at the rest of my client's testimony in context, he's saying, clearly I entered the plea because I relied upon my attorney's advice that there be no impact on the civil case. Okay, let me turn to the plea colloquy. I think the most common way that courts are using plea colloquies, as they should, to shut down frivolous 3.850 claims is this. A defendant enters an open plea. The judge gets to decide what the sentence is. The judge may explain, or someone may put on the record what the minimum on the score sheet, or if there's a minimum mandatory, and what the maximum is. You understand, I'll decide that sentence. It'll be my discretion at the upcoming sentencing hearing. Has anyone promised you anything? No. Defendant gets the max. Defendant turns around, it gets into prison, gets to the law library, someone says, you should file a 3.850, your attorney promised you were only going to get 20 years. Of course, in that context, and I think that's the main context, that courts say, you can't go behind what you said. You said you weren't promised anything. And now you're complaining that your attorney promised you were only going to get 20 years, even though the judge says the sentence is up to me? That's a valid use of the plea colloquy to defeat a frivolous claim like that. And I know this court has seen hundreds of them. I've read about them in Florida Law Weekly all the time. I don't think it's meant in this situation when it's not clear-cut, it's not specific, and again, there is that line of cases that talk about specificity, and you need to be specific in order to defeat a specific claim. And the best example is, and I'll conclude with this, oftentimes the defendant says, my attorney failed to advise me about an immunity defense. But then they go back to the plea colloquy, and the plea colloquy said, did your attorney advise you about all available defenses? And the defendant, of course, said yes, but the courts allowed that claim to go through under the reasoning that the plea colloquy was not specific. It didn't specifically address the immunity defense, and therefore you're not precluded from raising that claim in a 3.850. So for those reasons, I'd ask this court to reverse the denial of my client's motion to withdraw his plea. Thank you.
Thank you, Mr. Ufferman. Thank you, Mr. Wiseman. Well presented on both sides. That's the end of our OAs this morning, so we're officially in recess.